and remains capable of coming ever closer to the promise of equal treatment under the law that is so central to a functioning democracy. On several occasions, you have referenced that all the texts in the questions were simply personal opinions exchanged with a close confidant and in no way reflected your intent to act on your opinions. Yet, if you made these statements while on a jury, it is hard to imagine that you would not be kicked off immediately because of the risk that your bias would undermine a functioning democracy. Do you still hold that personal opinions, even in the face of Supreme Court precedent, should not have tainted your involvement on any investigation relating to Secretary Clinton or President Trump?
Mr. Chairman, I think you're mixing apples and oranges. I'm not an attorney, and I'm not familiar with that Supreme Court ruling. But based on what you said, protected categories, things like race, gender, ethnicity, sexual orientation, religion, are protected matters that we may not, the government and by law, people may not be discriminated against based on their role one way or the other in any one of those categories. That is entirely separate and distinct from political belief or political opinion. That, on the other hand, is encouraged, is protected by the First Amendment. And this body, under the Hatch Act, my understanding is, sat and said and recognized—
No one stopped you from sending the text, Mr. Strzok, but the special counsel, Mr. Mueller, removed you from the investigation when he saw the texts.
That's true, sir. He did. Now, if I may go back to answering your question, if I may. In terms of political speech, that is radically different from any sort of protected category of race, gender, and ethnicity or other categories. Political speech, political thought is protected. The courts have recognized, the Constitution recognizes, we all have political belief. And so when it comes to the expression of that political belief, that is something that this body, under the Hatch Act, enumerated kind of the categories of what was prohibited, and then expressly stated that if it is not prohibited, then it is expressly encouraged. So I would tell you that no one in here, it's an impossible definition to say people must not have political opinion. Everyone does. Of course they do. The test is whether or not that is left behind when you're doing your job. To your question of whether or not I would express that in front of a jury, of course I wouldn't. That would be inappropriate. As to your question of whether each and every one of those jurors, when they go home and they're sitting in their backyard with a friend, has a political opinion, my answer would be undoubtedly, almost if not all of those jurors would.
But they're instructed when they leave the jury panel each day to not communicate with anyone regarding the matter that they are considering. So that is a very different thing. You were considering a matter and you were conducting texts of a very biased, salacious manner that was totally inappropriate. And when Mr. Mueller saw that, he removed you.
Sir, I appreciate that concern. But what I'm telling you is there is a vast difference in my mind between an action as a juror being instructed by a judge not to discuss the matters of a trial compared to a citizen of the United States.
You don't suppose there's a reason why
discussing his personal
You don't suppose there's a reason why that instruction made. So the chair recognizes the gentleman from New York, Mr. Nadler.
Thank you. Let me begin by congratulating the witness on his completely correct statement of key First Amendment law, that people are entitled to political opinions. Now, you, sir, obviously expressed your political opinions as to Mr. Trump and Hillary Clinton and various others in text messages to Lisa Page.
I did.
And she to you.
Yes.
And these were private political opinions.
Yes.
Which you did not express publicly.
Correct.
And the Inspector General found, with respect to the investigation to Hillary, quote, "We found no evidence that the conclusions by the prosecutors were affected by bias or other improper considerations. Rather, we determined that they were based on the prosecutor's assessment of the facts, the law, and past department practices." That is correct, that is the finding of the IG, no?
Yes, sir.
Thank you. And with respect to the Russia investigation, the IG said that that he was disturbed by the appearance that investigative decisions might be impacted by bias, but made no such findings, and in fact hadn't completed his investigation of the Russia investigation. Is that correct?
Yes, sir.
Now, when people talk about the appearance, whether people on this panel or the Inspector General, the appearance of bias created by those text messages. Those text messages might create the appearance of bias only if they're public. Is that not correct?
That's correct.
Because otherwise there'd be no appearance.
That's correct.
And they were not intended to be public, were they?
Correct.
They were communications between two private individuals,
True.
which are totally permitted.
That's correct.
Now, are FBI agents permitted to have political opinions?
Yes.
And as a 22-year veteran of the FBI, could you tell us, without naming names, were you familiar with the fact with other FBI personnel having political opinions with respect to the presidential campaign?
I was.
And were some of these people anti-Trump?
They were.
And were some of these people pro-Trump?
Yes.
Thank you. And to your knowledge, did any of the pro-Trump bias or the anti-Trump bias and personal opinions affect decisions and investigations by the FBI?
Not to my knowledge.
Okay. Now, you mentioned the Hatch Act.
Yes.
Under the Hatch Act, the FBI is prohibited, is it not, from inquiring as to the political opinions of people it is hiring?
I don't know the Hatch Act well enough to tell you.
Well, I'll say that that is the case. The government may not, under the Hatch Act, inquire as to the political opinions of people it is hiring for non-exempt positions. And to do so would be improper. And I must say that I think that all of these inquiries about your political opinions as revealed by these text messages are irrelevant and wrong unless it can be shown, as it has not been shown, as was found definitively not to be the case in the Hillary investigation and has not been shown in the Russia investigation, that they affected any decisions in the investigation. Let's leave it at that on that point. Now, Mr. Strzok, what is the FBI's policy? Oh, and let me say one other thing. It is prudent, and I'll observe this because you said you couldn't answer, but it's obviously prudent of Mr. Mueller in finding these texts and hearing about all these text messages to think that they might be subject to incorrect interpretations on publicity, and in order to avoid the kind of attacks on this investigation that we are seeing from Republican members of this committee and from the administration, to ask you to leave that investigation having nothing to do with your competence or fairness in the investigation, but simply to somewhat insulate that investigation from unfair attacks. Would you think that that might be a correct?
Yes.
Thank you. Now, Mr. Strzok, what is the FBI's policy with respect to its agents commenting publicly about an ongoing criminal investigation?
We don't do that.
Sorry?
We do not do that.
And why is that policy in place?
I think for a variety of reasons. One, I think it is inherently unfair to the subject of that investigation. It can tend to skew the conduct of that investigation, other witnesses, other future investigative avenues. It can skew potential jurors in the event that a case is taken to prosecution. I can think of any number of reasons why we don't do that.
And are you thank you. Are you familiar with the Inspector General's report on the FBI's handling of the Clinton investigation?
I am.
And that report was highly critical of Director Comey, was it not, for, among other things, departing from protocol and commenting publicly about an ongoing criminal investigation.
It did say that, yes.
It was critical of him.
Yes.
And for doing that. And although some people have said that they don't agree with the decision not to charge Mrs. Clinton, in fact, the departure from protocol was the first departure from protocol, I should say, was Director Comey's commenting on on his opinion about her handling of various emails and so forth, having decided after she wasn't being charged, his departing from protocol was publicly commenting about that. Was that not one of the deviations from protocol cited by the report?
By the report, yes, sir.
Thank you. Has the FBI asked you to adhere to that policy of not commenting on ongoing criminal investigations, namely the Russia investigation, for example, today?
Yes.
How so?
They instructed me. My understanding is that General Counsel for the FBI met with Chairman Goodlatte and his staff and came up with an approved list of topics that I might speak about, and that outside of that list, that I was not to discuss anything having to do with ongoing investigations.
Thank you. And I will simply observe that asking you or anybody else, like Mr. Rosenstein, to comment on ongoing criminal investigations is against policy and is liable to taint those investigations.